Hi guys, sound check. If you can hear me, just type in a message. Sound check guys, if you could hear me, just type in a message. Hi guys, sound check. If you can hear me. Great. Yeah, so you have the questions with you. I guess you would have got the questions with you on the Telegram channel of ours. So I just gave it 5 minutes ago on the Telegram channel. So you can download the paper from there. And as it is, I'll show it on the screen also. मैं screen पे भी दिखाऊंगा. So let's start with the questions, guys, directly. Read the passage. Read the passage and then you'll have to answer the question also. Yeah. So ideal would be if you could download the paper from the Telegram channel. Otherwise, you'll have to go through this. Yeah. If you want me to change it, let me know. I'll change it. Move to a different slide. Yes, sir. That was intentional. That was intentional. I wanted to finish it together, as in to do the exercise together. That's why. I want to see how this works. Right. So all of you attempt the first set. Those who don't have the exercise, there would be a link to the Telegram channel. Follow that link and download the exercise, or you have the question in front of you. I just want to see that when we solve the question together, how does it go? If it doesn't work, then I'll share the exercise one day in advance with you guys. Hi Krishna, good to see you here after such a long time. Hi Laksh. So now if you've gone through this, what do you think will be the answer for one? Those who have marked the answer, hi Ananya, give me the answer. And when you give me the answer, give me the question number also. So let's say if you're marking D for 1, please write 1D. I hope all of you have downloaded the exercise from our Telegram channel. So this is the first paragraph, which is in front of you right now. This is the second paragraph. This is question number 1. Complete all the 5 questions. This is question number 2. We have made the questions slightly tougher as compared to the sample questions shared by CLAT consortium, at least in today's class. Right, the pattern is same, but slightly tougher. Those who will watch it later on and not in a live mode, my suggestion would be to first download the exercise from the Telegram channel, solve it on your own, and only then listen to the explanation. That's how it will be productive. That's how it will be more efficient. So guys, you are slow. By now, you should have finished the first set. I've only got one answer. First, someone as Mansi has given me the answer. What is the answer for number 2? This is number 3. This question is number 3. All right. We've already taken 10 minutes. And I can see only 2 people giving me the answers. Rest of you, guys, give me your answers. In fact, finish all 5 questions. This is question number 3. Now let's come to those who do not have the exercises can take a screenshot or a picture or a photograph from another phone and attempt it. Right. This is question number 4. and this is question number 5. So these are the 5 questions. Give me all your answers. Okay, Mansi, give me all your answers. Laksh, give me your answers. Okay, Avantika. Okay, Avantika has given the answers. Mansi, give me your total complete answers. All right. So I think going forward, I'll share the exercise with you beforehand. Right. I just wanted to see how much time are you guys taking when I give you the exercise. But then it will be a bit unproductive in this way. So going forward, I share the exercise with you and I discuss it here so that we save time on this. Yeah. So Paras answer is C. Okay. Yeah, Mansi, I saw your answers. Mansi, give all your answers, please, in one line. Paras has given the answers. Paras 2, you were not able to mark. Okay. All right. Okay. So before I come up with the answers, let's look at the passage, what all the passage covered, right? Before I give the answers, let's see what all the passage covered. Yeah. So basically, it discussed about this particular law, where all will it be applicable. So it says it will be applicable only to married couples. First thing is, it will be applicable only to married couples, and boy should not be less than 21 years of age, and the girl should not be less than 18 years of age, right? So these are the conditions. These are the conditions. Also will be applicable after the commencement. After the commencement. Okay, guys. So 2020, this law is being proposed. So let me ask you one question. Let me just see whether you understood the basic basic structure of the question or not. Let us say that there is a couple which satisfy this condition, this one and this one. Let's say a couple, and this couple has 3 kids. 3 kids, and this is before the commencement of this law, or before this law was passed, right? So let's say before 2020, these people have 3 kids. So will this law apply to them? Will this law apply to them? Will this law apply to them? Yes or no? Will this law apply to them? So let's say they have 3 kids before 2020. The condition says after the commencement of this law. So these people, one couple has 3 kids before 2020. So will they be punished? Will they be at a disadvantageous position as per the information given in the passage? Yes or no? Yes or no? Yes or no? I know there's a lag of few seconds, so you may respond now, but please respond. So a couple has 3 kids, but 3 kids before 2020. So will they be? Yes, no. The correct answer is no. Right. Yeah. So you got this right. Okay. All right. The benefits are that if both husband and wife with only one child undergo the operation, they'll get 3 benefits. As per the passage, they'll get 3 benefits, right? If they have only one child, then both husband and wife with only one child undergo sterilization, and the couple belongs to below the poverty line, then they'll have benefits under section 6. Plus, they'll get a lump sum amount, and the lump sum amount will vary whether that single child is a boy or a girl, right? This is the other aspect of the passage, right? And the final aspect of the passage was the disadvantages, right? So 5 of them if more than 2 children. So there are 5 disadvantages, right? So there are 5 disadvantages if The disadvantages are if you have more than 2 children. So this is broadly what this covers, right? And now you would have found this difficult because, as I said, there are three broad heads: applicability, disadvantages, and benefits. Applicability, again, there are certain rules. Benefits, again, there are certain conditions, and disadvantages, again, certain conditions. So for a passage like this, the person who's making the question, the person who's framing the question has lots of options, right? So let's come to questions now. This was the question number 1. The question is, would Rupa be eligible for preference for admission into the nation's top medical school when she comes of age? So this is talking about the benefit, and benefit was parents, both of them have operation and they have one kid. So do they have one kid, Rajiv and Shruti? No, right? They total have 2 kids. So one is here, the first child, Megha. To avail this benefit, you should have only one child, and the second was Rupa. So to avail this benefit, the condition said that you need to have only one child. Only one child. So answer here is this. Answer here is C. So even though the first child was before enactment of the law, in total now after the law gets commenced, they have 2 kids. So they can't avail the benefit. So first, the answer is C. First, the answer is C. Now, second, I've got variety of answers. Let's look at number second. Let's look at number 2. Okay. Now, first of all, the applicability. Applicability is these conditions would be applied if they are married. Right? Does this law apply to them? They are married couple. Yes, they are married couple. At the time of the law, when this law was passed, right, they are fulfilling the conditions. And how many kids do they have? They have more than 2 children, right? They have more than 2 children. And when did they have these 2 children? After they got married. When did they get married? Right? So total they have more than 2 kids. Total they have more than 2 kids, and all the questions are to be answered on the basis that the law is passed in 2020. The law is passed in 2020, right? So the law is passed in 2020, and if you have more than 2 kids, this is where the condition is: shall be debarred from, and there was this group A jobs, applying to group A jobs. This is also a disadvantage if you have more than 2 kids. So therefore the answer is, can he be allowed? He would be allowed, but not to a group A job. Now let's say, what all answers have I got? I've got second, I've got B, second I've got B, second I've got B. Majority of you marked B, right? You're saying yes, even though Raghu and Sumitra have a total of 3 kids, they conceived only 2 children post their marriage. The bill clearly states the constraint or a number of children is applicable only for married couples. See, they are married now. So even this third child would be considered as the kid, right? How many children do they have total? They are married now. If they were not married today and they had 3 kids, they would have gone outside the criteria. But now, today, as of date, they are married. So this law applies. So do you mean to say that 2 kids will be legitimate today and 1 child will not be? They are married now. So these 3 kids, so they are married now. So the conditions apply. And how many kids will you count? You'll count 3. So that is the condition. They follow under the criteria. They are married today, and today they have 3 kids. So this guy cannot apply. So therefore the answer is this. Answer is this. Is this clear, or do you have any doubt in this? Right. Second, the answer is D. There is a lag. If you have any doubt, you can type in the answer. Let's come to number 3. Right. 3, we have made this question with ambiguity, right? And what we expected you to mark, most of you to mark, was this. What we expected most of you to mark was C, right? What we expected most of you to mark was C. Now, as per the information, guys, it gives information that if you have 2 children, more than 2. Okay, let me come to that slide where it gives the conditions, right? So yeah, so it says, look at this. In the case of a married couple who have more than 2 children, shall be debarred from contesting in Lok Sabha, right? So the information is, the question number 3 is about this, right? Contesting Lok Sabha. So it says, if a couple has more than 2 children, shall be debarred from contesting in Lok Sabha. So this is, I already have 2 kids. Now can I contest in Lok Sabha? The answer is no. But what if I'm already in Lok Sabha as a member and now I have the 3rd kid? So future, I know next term I won't be allowed. Next term I won't be allowed. But what about this term? Is that information given to us? This clearly says, if a married couple who have more than 2 children shall be debarred from contesting, which is the future tense. Or let's say if I have 2 kids now, I can't contest. But what if I'm already a Lok Sabha member and now I have the 3rd kid? So this information is not given here. I know for sure that this guy cannot contest the next term, but will he be debarred in this term? The information is not available. That information is not available. So therefore the answer here is this. The answer here is this, right? Are you with me, or do you have strong opinion about this, against this choice? Right? So please understand, the information says that if you have 2 kids, you will not be allowed to contest, but more than 2 kids, sorry. But what if I have more than, or I have my 3rd child during my office in Lok Sabha? That is not been given. That has not been given. So therefore the answer for 3rd is D. Let's come to question number 4th. Let's come to question number 4th. 4th is straightforward. The benefit was given only if you have 1 child. This benefit is only if you have 1 child. So now this says there's an amendment which says if you have twins or triplets, it would be considered only 1. It would be considered only 1. How many kids do they have? Dibban, Pratik, Derivage, Rubbers who combine income below poverty line have 1 daughter. They already have 1 daughter from their first delivery, and then they have twins. So this would be considered as 1. So, but 1 plus 1 is 2. So they won't fall in this category. They have 2 kids. Calculation wise, they have 2 kids. To avail this benefit of lump sum amount, you should have had only 1 child. So they are not eligible. So 4th, the answer is C. 4th, the answer is C. Yeah. Now let's come to question number 5, which is this. 5th, what have you marked? What have you given me an answer? 5th, B, C, C, B. Okay, let's read number 5th. The state of Haryana has one of the most skewed sex ratios in the country, and the state government wants to encourage the birth of more girl children to address the issue. The average fertility rate for the state is 1.7 per woman. The state government wants to waive off the penalties for more than 2 children if all the children are girls. What is the likely instance of Abhishek Manu Singhvi? Right. So the information here, extra information here is the fertility rate here is 1.7 per woman. So the answer here would be dependent on this, which is this. The bill also calls for introduction of compulsory subject where the average fertility rate is more than the replacement level of 2.1 children per woman. So now, if you don't know the meaning of replacement level, I hope you all of you know the meaning of fertility rate, right? So if I say fertility rate is 1.5, that basically means that a woman uh, gives birth to 1.5 child on an average, 1.5 children. If I say birth rate is 1.5 or fertility rate is 1.5, that means one woman gives birth on an average to 1.5 children. Replacement level, even if you don't know what replacement level is, please understand the connection between fertility rate and replacement level. It says if fertility rate this is more than 2.1, I have to take some extra measure, which means if fertility rate is less than 2.5 or less than replacement level, it is still better. If fertility rate is more than replacement rate, then it's a matter of concern. This is what, if you have figured out, that is more than enough to answer the question. Replacement level means on an average, if you want to replicate the entire generation, how many kids do you need to produce? So if you have 2.1 kids per woman, the entire generation will replace itself in certain time period, right? Okay, so now let's come to that question. So my fertility rate is less than my replacement level. So therefore, the Haryana government says that we would like to propose this thing. So what with Abhishek, Manu Singhvi on this do? So the choices are between B and C. Majority of you have marked between B and C. Let's look at B. Allowing for more childbirths will miss the core issues behind the adverse sex ratio, right? Because and will likely worsen the national population versus resource situation, because if you are trying to get 2 kids and girls are allowed, right, it will be pressure on resource, and also will it be able to cater to the problem of adverse sex ratio? Maybe not, because girls sex ratio is low on because of different reasons. So this might not help to cater to that reason, plus it would worsen the situation which is facing. So B is the correct answer in this case. Let's say when people mark C, what did you mark? Mr. Singhvi is likely to support the proposal if the rewards as well as the penalties are waived off. Both penalties are also waived off. Doesn't make sense. There is no disincentive. Yeah. So C doesn't make sense. See, main thing is Abhishek Manu Singhvi wants to have a two-child policy, which means I have to reduce population. That is the main thing. And this, what you're suggesting, will not help adverse sex ratio. So he would likely oppose state governments of proposals. So the answer is B. Fifth, the answer is B. If you have any issue, guys, thoda likh dena usme chat box mein. Even if there is a lag, but I'll come to that. Okay, let's come to passage number 2. Okay, passage number 2, guys. Those who don't have the passage, download it from our Telegram channel. Otherwise, take a click of this image. So this is the only only paragraphs. It's a one slider passage. Go through the passage and mark answers for this. This is the passage, and these are the questions that follow. Yeah. Once you finish the passage, give me your answers. Once you're done, give me the answers, guys. This is the passage, and this is question number 1. This is question number 2. This is question number 3. Question number 4. And finally, question number 5. These are the 5 questions. Give me the answers, guys. Answers, guys. Give me your answers. So yeah, for the next session, I'll give you exercise beforehand, one day in advance. Okay, so Mansi has given the answers. Okay, fourth, you are confused. And what about fifth? How about Mansi? How about fifth? Avantika, your answers. Paras, Anika, Vrinda, Krishna. Give me your answers. We've also mailed you the schedule for the classes, right? We will mail you weekly schedule now, and there are lots of sections which we'll be doing on YouTube. So I think today we have a con section also, right? And you could go through the channel and see the schedule. We've already put the other sessions on schedule. Okay, so only Mansi has given me the answers, guys. Others are taking a lot of time. 2 more minutes. After that, I'll give the answer. Mansi, you may attempt the third passage in the meantime. Those who finish the second passage, give me the answers and then proceed to the third passage. 2 more minutes and then I start discussing this passage. No issues, Mansi. As I said, we have picked up passages, and we in the first, let's say, first two sessions, we are coming up with questions which are slightly tougher as compared to the your actual paper. All right then. So let me give you the answers. Others are taking a lot of time, I guess. I hope you don't take this much of time in your let's say the sample papers which has been shared by CLAT consortium, right? Because otherwise we are taking a lot of time if that is the case. Yeah. So in this one, let's go to first. What all has been discussed? Lakshay, to answer that question, it depends. As in, how much do you read? Do you read novels or not? Do you read newspapers or not? It depends on that, Lakshay. Okay. So what all has been covered? Now compare this passage with the earlier passage. The categories are limited, right? The categories are limited. You have civil contempt, criminal contempt, and you have sui generis. These are the three categories, broad categories. For civil contempt, the key word is there has to be willful disobedience. Guys, always look at the criteria. The key criteria for civil contempt is there has to be willful disobedience. It is private in nature. It is private in nature, as in you are not causing harm to society or something. You're causing harm to the person against whom you're not fulfilling your responsibility. So court would have given a judgment that you have to do this, or you have to compensate this party like this, and you disobey willfully. So you're causing harm to that person. And the purpose under civil contempt is to right the wrong done. If you're not done something which you're supposed to do, court will make you do that. As compared to criminal contempt, it's a wrongdoing against the society that has been given to us. It's a wrongdoing against the society. It lowers the authority of any court. Any act, any behavior which lowers the authority of any court, that will also come under criminal contempt. And your sui generis is a mix of both. It's a mixture of both. Yes, open to interpretation, Mansi. But see, what are the categories given to us? First of all, it has to be private, right? So let's say I am creating a environmental harm to the society, right? So is that a private thing or a criminal thing? It's a society thing. Or first of all, you have to decide my act, is it leading to a private harm or society harm to society, or this lowers the authority of any court. So that is how you differentiate between civil and criminal, right? And something which is in between is sui generis. Now let's look at the questions. Let's come to the questions, Mansi. Okay. Question slide is 11. Okay. Look at this one, right? Loses tenancy case against his landlord, Dude Thakur, and is directed to vacate the flat and pay last 6 months of unpaid rent along with interest. So first of all, is this a private case? Yes. Till now, it's a private case. It could also lead to sui generis, depending on how he takes it. If he lowers the authority of the court, this guy, then it could be sui generis, because right now it is the private thing. He pays up the rent and the interest, but refuses to vacate the flat. He criticizes Dude Thakur's greed, the incompetence of a lawyer, and the deviousness of the landlord's counsel in front of his colleagues at work. All right. So is this a civil contempt? Yes, this is a civil contempt. It's a clear-cut case. It's a civil contempt. Right. So first, the answer was A. First, the answer is A. Right. Let's move to question number 2. Bhavani's brother Mitesh is convicted in a dowry harassment case in Allahabad High Court. His wife is granted divorce and he is ordered to pay hefty damages as well as an alimony. The verdict comes as a surprise to all his friends who know Mitesh as a mild-mannered gentleman. Okay, they pool in funds and decide to help them appeal the verdict. Bhavani is journalist and decides to do her bit in her brother. She writes several articles challenging the previous judgment verdict and highlighting the incompetence and bias of the judges who presided in the case, right? Mitesh appeal is successful in the previous judgment they decided and a fresh hearing is ordered. Now, guys, important thing here is you don't have to use external knowledge. You have to use only what is given to us. So what is given to us here is, right? Look at this. While the criminal contempt is more of wrongdoing against the society at large and, for example, scandalizes or tends to scandalize or lowers or tends to lower the authority of any court. Now, it doesn't say whether it is justified or not. If it tends to lower the authority of any court, that will come under criminal contempt. Now, no external knowledge. You have to mark only from this Mansi. So this act, her act, when she's challenging, highlighting the incompetence and bias of the judge, is she lowering the authority of the court? Yes or no? That is what you need to answer. Is she lowering the authority of the court? The answer is yes. The answer is yes. Do not apply the concept of defamation or something else. Truth prevails. No, that is not to be applied. Here the line says it should not lower the authority of the court. Her act is lowering the authority of the court, and therefore the answer would be D. Therefore, the answer is D. Whether it was correct, not correct, we don't know why this judgment was rescinded. That we don't know. That also we don't know. Two things. First of all, the information does not say that if it is a factual thing against the court, whether that allowed to lowering the authority of court or not. And second, in this case also, if his appeal is successful, we don't know whether it is successful on the basis of incompetence of the previous judge. That we don't know, right? So therefore, the answer is D. Second, the answer is D. Now let's come to question number 3. Can Ajit's ex-employer accuse Ajit of contempt of court? So first of all, right? Contempt of court. So you basically, his not accepting the offer is not a contempt of court because it was private against the beneficiary. In this case, he was the beneficiary, right? So that is not civil contempt of court. You have to think whether it is criminal contempt of court or not. Right now, did the information, Mansi, say that it has to be public forum where your behavior leads to lowering the authority of court? Mansi, did this information mention that the lowering of court has to be done in the public forum and in private forum it is allowed? The information did not mention that. Or lowers to tends to lower the authority of any court, where that is not given. So it is a general statement. Whatever you do, if it lowers the authority of the court, it would be criminal contempt of court as per the scenario given here. So therefore, if you're marking answer this on a private group, this exception is not been given. This exception is not been given. Therefore, the answer would be B. It's a criminal contempt. He's lowering the authority of the court, even if he's doing it in front of 2 or 3 people. He's doing that, right? Therefore, the answer is B. We have intentionally put this question because we know what kind of errors you guys can make. You know, especially I have the advantage of teaching you guys, so I know what kind of mistakes you make, right? So the boundary was general. Mansi, please understand, criminal contempt of court is if you lower the authority of court where not given. So from that, how can you say that he was doing that in private group? So that is fine. Yeah. So therefore, third, the answer is B. Let's come to number 4. Fourth. Okay. Now in this case, what has happened? State-run and state-owned vehicles are charged to electric vehicles to install electric charges point across the state. Owners to also transition to electric vehicles and to reduce taxes on electric vehicle sales to make them for affordable. The Delhi government implemented none of these rulings, citing lack of adequate resources and budget constraints. Would the court be right to consider imposing a fine on a Delhi government and also to imprison some of the higher functionaries in the government for a week to send out strong message? Right. So the key word here was, is this a willful? Is this a willful contempt of court? Is this a willful contempt of court? Right? The answer is D. It is not. The state government has not implemented the court orders not out of willful disobedience. The government is not saying we don't agree with your judgment. It's because of incapacity. So it's not willful disobedience. It's not willful disobedience. That is a key word here. Right? Because there is no willful disobedience, therefore the answer is D. Most of you marked what? In fact, most of you did not give me the answers. You marked fourth ka, you were confused between B and D. Look at B. Yes, the state government's lack of action puts the entire population at severe health risks and should be considered as a wrongdoing against the society at large. Hence, it's a case of criminal contempt, and according to the court, should consider punishment and fines apart from any sanction it deems appropriate. Let's go back to the passage. Right? More of wrongdoing against the society at large. So this is not, it's a proactive action, not a response. Right? So it's not that a judgment was given, then you did this something. This was already been done. Right? So yeah, the close choices were this one. B and D were close choices, but D is clear. Because see, if an award was given and I'm not doing it, the beneficiary in this case was the public at large, but I did not do it out of willful disobedience. That is why the answer is D. Yeah, it was a tricky question, Mansi. Okay, let's come to fifth. Fifth, I think, was straightforward. Fifth was straightforward. Okay. it has questioned both the integrity and competence of Justice Roy, highlighting that his father was a senior functionary in the ruling party and that Justice Roy had failed to clear his matriculation exams twice. No, so this is clear cut lowering the authority of the court, clear cut lowering the authority of the court, right? And therefore the answer would be B. The answer is B. I don't think anybody got this question wrong, right? So again, compare this with the previous one. There are limited conditions. As I said, Mansi, there was, first of all, there is no question on sui generis. They could have asked a question on sui generis also. So there was no question on this, but it was civil and criminal. You had to understand what will come under civil, what will come under criminal, and it was not open to interpretation. As you said, the criteria was given: willful, private, lowering the authority. You got confused defining the scope. So when it said lowering the authority, you thought in public versus private. It was in general. Yeah. Okay. Last set. Okay, let's come to the last set, which is this. This one is also a bit subjective. Yeah. See, we have come up with these passages because the passages that CLAT has come up with, the consortium, I think you guys are finding it extremely simple. And we hope that kind of paper comes in the paper. But if they were to complicate things like this, you should be prepared for that also. So that's why we have slightly complicated it by applying logical reasoning, by applying critical reasoning. Yeah. Okay. Guys, those who are new to our channel, kindly subscribe to our channel. With that, you will come to know whenever we are doing sessions, and we are doing lots of sessions. This month we have packed our schedule. There will be lots of classes on logic, on GK, on legal knowledge, on your let's say legal reasoning, on maths. So those who are new to this, do subscribe to our channel and do subscribe to our Telegram channel also, so that you get to know of the schedule. Yeah, last passage. This is the first paragraph, and this is the final paragraph. Okay, I give you 5 minutes. Give me the answer for this, guys. 5 minutes. Answer. So day after tomorrow, again, we have a session on legal reasoning. I'll share the paper 1 day in advance. I'll immediately come and start discussing the paper. I think in that case, we'll be able to finish the session in half an hour. I'll discuss only 3 passages. These are the questions. Those who have done this can give me the answers. Okay. Okay. So my bad. Okay, guys. Can you hear me now? Okay. All right, guys. Okay, so I repeat. Okay, so guys, there are two things which has to be noted here. We picked this article because there are two things which are happening. A in something which has been done by the Supreme Court, and the author's reasoning. There are two things that are happening. Can you hear me now, guys? Can you hear me now? Mansi, can you hear me? Rukmini, can you hear me? You guys, can you hear me? Yeah. All right. I think you guys can hear me now. Perfect. All right. Just type in a message, can hear you. Just type in a message, can hear you. But I think you can hear me now. I checked it on my phone. Let me check it on my phone. Can you hear me? Right. I think you guys can hear me now. Yes, you guys can hear me. Okay. So basically, see, first of all, because it is Article 16, we are just simply cannot use our external knowledge that fundamental right is available only against the state, right? So whether it is state or private, from this passage, it will be difficult. But here it says government services. So from that, I can base that it applies to government services, maybe. Second thing, please understand that the Supreme Court recent stance as per this passage has been given to us, which is that Article 16(4) of the Constitution is only an enabling provision and does not confer a right to reservations. So this is Supreme Court's stance, and the other stance is of the author. So same question can have different answer depending whose logic we have to follow. So if we follow the logic of the author, we might have a different answer. We will have a different answer. And if we follow the logic of Supreme Court, we'll have a different answer. Okay. All right. So let's come to the question directly. First, state government survey reveals that there is adequate representation, but not in private sector. Not in private sector. So it was in government services. So this does not apply. So answer is no action is to be taken. This is a clear-cut answer. I think most of you have given me the correct answer, which is first A. Now let's come to second. Okay, guys. Also, the passage was talking about the author's main argument is substantive equality. Substantive equality. So the main premise is substantive equality. Substantive equality basically means there should not be any indirect discrimination. If you have studied for CLAT and if you've gone through Constitution and Article 16, you would know that equality basically uses the concept of equity, which is similar positions should be treated similarly. And therefore, there's a reservation thing because two people could be in different situations, right? A person with a net worth of 1,000 crores may at times may not be similar with a person who is a rickshaw puller, right? So substantive equality means there should not be any indirect discrimination. There should not be any indirect discrimination, right? And again, the principle comes from that equity, right? Similar situations should be treated similarly. So a person who has a tribal background, whose parents, grandparents have always lived in a forest, and that person somehow, due to his own effort, comes to a level where he is facing an, let's say, a group discussion kind of a scenario. So now it won't be fair for him because the situation is not same. He compared to a person whose both the parents are working, who comes from a cosmopolitan culture, has studied in an English medium school. So the situations are not similar. So in that case, that person will not have substantive equality. If the selection would be based only on the basis of group discussion and how do you communicate there, that would not be substantive equality, right? So now let's come to the answer question number 2. State government survey reveals that there is inadequate representation of scheduled castes and scheduled tribes in state government services. Which of the following, if true, would still allow the state government as per the author's line of reasoning? So author's line of reasoning was substantive equality. Substantive equality. So out of these 4, which one is proving that there is substantive equality? Right? Which one did you mark? You guys gave me second. The answer you gave me is D. The Supreme Court has upheld the state government's contention that there is no right to reservation. Now, this one is not as per the line of reasoning of the author. That's what I said, Mansi. Question categorically asked as per the author's line of reasoning. So author's line of reasoning is, so long you give substantive equality, that is fine. That is why we picked this passage. This passage has two logics, Supreme Court and author. The question is asking you about author's line of reasoning. I hope you got a mistake here, Mansi. So if author's line of reasoning we take, so that means substantive equality, and that would come from B. Because there is no discrimination, people are opting out of it out of their own choice. They are finding business to be a better option than opting for state government jobs. So which means system has not created any indirect discrimination. They are exercising their choice. That's why option B is correct, because it signifies substantive equality. They are not applying it because there is discrimination. They are not applying because there are better opportunities available. Yeah, Mansi, that's why we are picking such passages. We are picking such passages where you might commit certain mistakes, right? So that's why I said in the beginning there were two logics which are being going here: authors and Supreme Courts. Yeah. Okay, let's come to number 3. Which of the following could be an example of an action taken to implement the principle of right to substantive equality of opportunity? Substantive equality, as I said, there should not be any indirect discrimination, right? Which will come from D, because people who are economically weaker section are naturally at a disadvantageous position. So how do you remove that natural disadvantageous position? By giving them certain relaxation. So which is option number D? Third, the option number D is the correct answer. Let's come to question number 4. From the passage, it can be inferred this again. Supreme Court has given this verdict. So this is a clear-cut answer. Supreme Court has said that it is a choice, it is an exception, right? It is up to them. That is what Supreme Court has said, right? Slide 70. Right, where was it? This was it. Supreme Court, it's an enabling position. That is a stance which it has taken. So, all right. So, fourth, we could answer A. Fifth, if there is an adequate representation of any group in the public services, then this is an interpretation question, a comprehension question. If, and this question is linked with this question. Question number 2. What if true will still not be a violation of Article 16(1), which means that there is no representation because people are exercising their choice, right? So there is no discrimination. They are exercising their right. They're exercising their choice. So they are not discriminated. So this and fifth are linked. If there is inadequate representation of any group in public services, then a case of reservation arises only if inadequate representation is due to this, and this, because this would ensure that there was no substantive equality. So this one is also a tough question. But again, if you look at the other choices, the other choices were easier to eliminate, and therefore the answer is C. Fifth, the answer is C. So basically, we are picking up passages and we are making questions where you might commit critical reasoning errors, right? So you might find it slightly tougher, the first few them, but these are important, because if you get a question like this exam, you should be prepared for this. Yeah. So with that, I come to the end of the session, guys. For people who don't know us, we are Eptitude. We take classes for undergraduate law entrance preparation and for business management preparation. Exams like CLAT, IIT, LSAT, and for business management like IPM, IIM Indore, Rohtak, and DU-JAT. We offer both long-term courses as well as short-term courses. We provide online classes on our platform. We have got our own platform, so which is different from YouTube session. Other than classes on our own platform, we conduct classes on YouTube live sessions. This is one of the classes, YouTube live sessions. Check our channel. We have planned a lot of sessions throughout this month, both covering English, legal, your logical, maths, everything, right? So just stay in touch, subscribe to our channel, and help promote our brand by sharing a link amongst your friends and all. test series, as I said, become extremely important for any examination, guys. Test series is extremely important, right? So for CLAT, we will be coming with our test series towards the last 10 days so that you have a test series ready with you. You can already go through the sample questions that we are solving in a YouTube live session, ताकि आपको आइडिया हो जाए कि किस तरह के क्वेश्चंस हम कर रहे हैं, what is the quality of our question. But I think you should definitely go for our test series. Plan it in such a way that the last 15 days you spare for our test series, both for law as well as for business management. So with that, guys, I would like to end my session. Thanks a lot. Your feedback on the comment section. If you like it, just click on the like tab and do subscribe to our channel who have not subscribed to our channel already. Thanks a lot. Thank you, guys. Thanks for your time. I hope you like the session. Thank you.